What kind of precedent are we, by allowing a new business owner of Miami Beach to be shaken down? This is the first time he's met Michael Larkin or did business with Michael Larkin. And at the whole time, he felt like he was getting shaken down. This feels like extortion. There is 100% a lobbying effort to pass this item. And I totally understand that, but there is literally a law that prohibits a contingency fee. It seems that this $1.2 million payoff is being tied to how we and our committees vote on this project. It's a settlement agreement that was prepared by you. And I'd like to point out some serious concerns that I believe my colleagues should be aware of. This is the section of the settlement agreement where the standard owner shall pay a total sum of $1.2 million. This raises serious ethical and dangerous precedents.
Commissioner, I'm not going to allow a committee member to say that something that we are not a party to is influencing anyone's vote up here. Hearing of this,
I have on my phone text messages being lobbied on this item. A gamble is being made on how we and our committees vote on this project. And I think that's highly disturbing, and it's against the law.
you're recognized.
Thank you, Mr. Chair. Mr. Larkin, how long have you been practicing law in Miami Beach? Land use.
98.
Okay. Are there any projects similar to this one where there's been a settlement agreement where you've personally brokered between a business owner and a civic group?
There were a couple recently with the Friends of South Point Elementary where it was a settlement agreement and we gave them a certain amount of funds they've already used. I just knew that a few days ago. They told me they used to our soccer field at South Point Elementary, so that was a good use of the funds. Much earlier, it wasn't with a civic organization, but typically sometimes private parties do approach you and say that they'll object unless you give them compensation. That happened on Collins Avenue a long time ago. So every project's a little bit different. But with regard to a nonprofit group, yeah, we did enter into an agreement with the Friends of Southwood Elementary, and I think it helped that elementary school a little bit.
Would you say that this particular settlement agreement is contingent upon a government approval?
I don't think it was worded like that.
Okay, well, I assume you're familiar with the cities and counties' prohibition on contingency fees as defined in our code, correct? PJ, can you pull up section 2485.3? The contingency fee. Okay, let me read this to you. Contingency fee prohibited. Yeah. If you could zoom in a little bit so people can read. No person or entity may, in whole or in part, give or agree to pay or give a contingency fee to another person. No person may, in whole or in part, receive or agree to receive a contingency fee. As used herein, contingency fee means a fee, bonus, commission, or non-monetary benefit as compensation which is dependent on any way or contingent on the passage, defeat, or modification of three parts: an ordinance, resolution, action, or decision of the city commission, city manager, or any city board or committee, or any action, decision, or recommendation of city personnel during the period of time, the entire decision-making process regarding such action. Decision, recommendation, which foreseeably will be heard, reviewed by the city commission or a city board or committee. So, you could end the slideshow, PJ. Do you have a copy of the settlement agreement here today?
No.
I do. Okay. And I want to share with my colleagues. And I have one copy for you. Pass it down. Would you like one, Mr. Larkin? There you go. PJ, now can you pull up the settlement agreement so that everyone can see, please? Okay, so here is a settlement agreement that was prepared by you. And I'd like to point out some serious concerns that I believe my colleagues should be aware of. PJ, if you could scroll to page 10, please. Okay, yeah. All right. So this is the section of the settlement agreement where the standard owner shall pay a total sum of $1.2 million to BIRA in the following 3 installments. Okay, part A, 30% within 15 days of execution, which apparently has already been paid. 30% of within 30 days of a final non-appealable approval of the development approvals defined by 30 days after rendition of a design review board order, which has already happened, approving the project, or the effective date of proposed legislation, whichever comes later. And lastly, 40% within 30 days of an issuance of a master building project in furtherance of the development approvals. These payments shall be made to a nonprofit entity established by BIRA for physical quality of life, and get this, lifestyle and cultural improvements to Belle Isle as determined by the not-for-profit entity established by BIRA. You could put the slideshow down. When I found out about this, the reason I found out about this was because of the person in today, Joe Ferrone, during the DRB meeting, told me that there was a $1.2 million payout. I couldn't believe it. I looked her up. I couldn't find her phone number. I knocked on her door. I went to her house and I knocked on her door. You know, I have serious concerns about the process we are witnessing here. It seems that this $1.2 million payoff is being tied to how we and our committees vote on this project. This raises serious ethical and dangerous precedents.
Commissioner, I don't know what's happening on the outside, but I'm not going to allow a committee member to say that something that we are not a party to is influencing anyone's vote up here. So if you want to continue with your presentation, continue, but I'm not going to allow anyone to say that anything is influencing our decision making, because this is the first that I'm hearing of this.
I have on my phone text messages being lobbied on this item. There is 100% a lobbying effort to pass this item. And so now we have a situation where a new entity has been formed and payments are being made contingent upon a government approval. While I don't necessarily blame the business owner for this structure, this feels like extortion. I mean, guys, what kind of precedent are we allowed to be set here by allowing a new business owner of Miami Beach to be shaken down based on contingent deals for $1 million?
So,
if you let me,
I just want us to be clear about something. We have nonprofit organizations that have worked with private applicants in the past to get public benefits for their organizations. The city has received public benefits as a result of projects that have been approved in the city. The park at 5th and Alton was a public benefit as a result of a project that was approved for the city.
but that was done through an open, transparent process. This settlement
But
agreement
that's
was done.
government. Government is subject to an open and transparent process. BIRA is a neighborhood association, and they're not subject to the same rules. So I'm just providing
Correct,
context.
and I totally understand that, but there is literally a law that prohibits a contingency fee. And this is, and the way this settlement agreement is structured is that it's contingent upon our approval. There is being a gamble is being made on how we and our committees vote on this project. And I think that's highly disturbing, and it's against the law. And if you don't mind, look, I called the owner of the Standard when I found out about this. I called him, and I go, how did you feel about this? And he was upset. He was livid. He's like, yeah, I didn't want to pay a dime. And he said this is the first time he's worked in Miami Beach. This is the first time he's met Michael Larkin or did business with Michael Larkin. And at the whole time, he felt like he was getting shaken down. He also told me that this, this undergrounding, this settlement agreement was supposedly to pay for undergrounding wires or sidewalk improvements. But if that was the case, that should have been a proffer to the city by the business owner. It shouldn't have been done through a backdoor deal. BIRA doesn't own any property. They're a neighborhood organization. They have sole discretion whatever they can do with this $1.2 million. And so I find it highly disturbing that these deals are being made on the side for 7 figures, where it's dependent on how we vote. Look, I like this project. I love the project. I like that we're enhancing the standard. It's going to be beautiful. I don't have a problem with the project per se. And in fact, if you look at that agreement, most of the agreement covers really good quality of life stuff like parking, noise, hours of operation, no special events. It's great, but it shouldn't cost $1.2 million. I mean, seriously, what kind of precedent are we setting here if we allow this
Commissioner,
to go forward? I mean,
let's wrap up because we have other commissioners I want to be recognized, including the sponsor of the item.
sure.
So public benefits are not anything nefarious or to be embarrassed about. Joe's neighbor is paying the city almost $1 million for their air rights agreements. So public benefits happen all the time. And to try to make this out to seem like it's something hidden or nefarious is wrong. And the community deserves to get undergrounding and deserves to get funds to pay for things that'll make Belle Isle better. So I'd like to continue with the item and see if we have the votes to pass it.
Well,
Thank you. Thank you. Mr. Attorney. And I'm glad the Inspector General is here because I just need to know, I need to have clarity. Mr. Attorney, an ordinance was put on the screen. Explain to me that ordinance. I'm being hit from left field with all of this information that I didn't have before. So explain to me this ordinance.
I'm happy to walk you through the ordinance. Before I do, I just want to set the stage a little on the kinds of settlement arrangements that people enter into before a land use board approval, because parties are always encouraged to settle their potential objections to a project or design changes that are requested or operational conditions.
For example, the park in North Beach that we're getting on Ocean Terrace.
Well, that's a different story. So what this code section deals with is third-party arrangements with lobbyists or other individuals who are appearing before the city in support of or in opposition to an item, right? So I just focusing on the sort of settlement agreements that people enter into before projects are approved. Often it's a matter of a simple conversation where a neighbor says, can you move your driveway, or can you shift a window so it doesn't look directly into my apartment, right? We see we see those all the time. We also see there are also agreements between neighboring property owners that we never see because we're not a party to them. So this one is I will say it's unusual in that we have a copy of it at all and we're able to see it. But just taking all that into account, there is an exception from the definition of lobbyists for representatives of neighborhood associations who appear without any special compensation for that appearance. However, those individuals are still required to register and are still subject to the provisions of our code of ethics, right? So what the specific section states, Mr. Chairman, this is the question you asked me, and this is section 2-485.3, prohibiting contingency fees. What the section states is no person or entity may, in whole or in part, pay, or give, or agree to pay, or give a contingency fee to another person. No person may, in whole or in part, receive or agree to receive a contingency fee. As used in the section, contingency fee means a fee, bonus, commission, or non-monetary benefit as compensation, right? So I think, this provision is not implicated because a neighbor agreed to changes to a project, to operational conditions. It's not even implicated because a neighbor agreed to, or a neighbor or a developer has agreed to pay monetary payments to the neighborhood association. But what would implicate this section, just to be very clear, what would implicate this section are payments that are contingent on the outcome of a city decision, of a city approval. So if the agreement addresses, and I'd like PJ, if you could, to put it up again.
Yep, it says it right here, with 30% within 30 days of the final non-appealable approval of development approvals, defined as 30 days after rendition of the DRB order approving the project, or the effective date of proposed legislation.
Right. So that's that second payment, and then
And who is responsible to abide by the terms of this ordinance? Is it the applicant? Is it our residents? Like who's responsible for that?
the code sec, and just to be clear, it's the second and the third payments that would implicate this section, but the responsibility is on anyone who's appearing before the city, right? So it could apply to a lobbyist, it could apply to an individual exempt from the definition of lobbyist, but is otherwise required to register, like a neighborhood association. Frankly, it says no person may give a contingency fee to another person. It's written the code section is written very broadly. Now, I will say that this section is within our code of ethics, so it is subject to enforcement by the Miami-Dade County Commission on Ethics.
Okay. I think we have to be very careful because I do think that neighborhood associations are independent entities. They're not part of the government. They're neighbors who come together to look out for the best interest in a much more localized way for their neighborhood. And we all the time tell lobbyists to contact the neighborhood associations. And neighborhood associations look out for their best interest, and they enter into these agreements. And I think that the action that we take on something like this could end up hurting neighborhood associations throughout the city, depending on the precedent that we set here. Associations should be able to meet with project applicants. Associations should be able to seek benefits for their neighbors. That is nothing unheard of. It's happened in the city historically. I think we should be aware of it. Frankly, I don't like finding out about it in this setting. And I think, Mr. Attorney, we need to work on language to make sure that there's proper disclosure and transparency on that, because I frankly really don't like sitting here and having this thrown at me, especially when people speak to me on a very frequent basis about these items. So I really don't like being surprised in this way at all. So there needs to be a level of transparency here. But let's be very clear: our own government engages in this activity. Our own government. We have received a number of benefits for the community, for the public, through projects that we approve. It's how we ended up with a beautiful new park at 5th and Alton. It's how we've ended up with so many other public benefits throughout the city. It's through agreements like these, except this one is being done by a private party, by neighbors who are fighting for their own individual interests for their neighborhood. It's not to personally enrich one resident. It is an agreement that enriches the neighborhood, that enriches the common good of the Belle Isle neighbors. Commissioner Suárez.
Let me speak to that, because I understand that you mean well, Mr. Fernandez, but in reality, only 3 people are receiving $1.2 million. This was a newly formed entity that is maybe a month old, and there's only 3 signers on this check with completely no oversight, no accountability on how this $1.2 million
Okay,
is going to be
but
spent.
wait. Hold up. The Belle Isle Neighborhood Association has been long existing. It's no different than the city commission.
But
It's
the
like
enti-
say-
the entity that's
I
being
have
paid-
the floor. Commissioner, I have the floor. It is like saying that the 7 members of the city commission are benefiting from the $1 billion budget of the city. No, absolutely not. We are acting on behalf, we are the stewards of the public. We're acting on their behalf. Any neighborhood association, you'll have a handful of officers, 2 or 3 officers. That doesn't mean it's benefiting or enriching those 2 or 3 people. They're acting on behalf of their residents, no different than how the 7 of us act on behalf of the constituents of the city of Miami Beach.
If the payment was being made to BIRA, that would be a valid point, but it's not. If you look at the agreement, it's a newly formed entity created by BIRA. And I looked at that entity, and there's only 3 individuals. 3 individuals are going to have the sole discretion to spend $1.2 million on how they see fit. And I understand the argument of a park and a public benefit, but that goes through a public process. There is transparency, there is integrity on how that is being dealt.
So,
Through this, we don't have any situation. And in fact, we have a landowner here, Joe, who's going to testify that she's been completely left out of this process. She never got a message from BIRA, and she is directly impacted by this project. This is how I found out. I didn't find out because I didn't like the project. I found out because at the DRB meeting she spoke and she said that I was never involved in this project and that there was a $1.2 million payoff. To me, a red flag goes up in my head, especially when it's that large of a
And
sum.
sometimes it might be good to have structure on neighborhood associations, to have advertised meetings and elections, because sitting on this chair, I have seen that sometimes it is good to have a level of transparency on neighborhood associations. I'm just going to ask the attorney, what is the best course of action? Because I have to say, I really feel very uncomfortable right now.
We should ask the Inspector General.
And I just, Mr. Attorney, I need you to guide us on the best course of action with this right now. Because I need to know this entity that was formed, are we familiar with this entity? What do we know about them?
Mr. Chairman, what I can tell you is you have an item before you that references legislative amendments for the standard. What we have learned is that there was a settlement arrangement between the developer and a neighborhood association on the island. The agreement addresses a range of terms. We obviously are not a party to that agreement, so I'm speaking to you just having looked at it on a few slides. But the parts of the agreement that relate to changes to a project or operational conditions, I don't think, even the first financial payment, I don't think implicate our code, but I am concerned that the second and third payments may. And so it's up to you all if you'd like to ask BIRA to speak to any of this. If it could even be that their intent was to work with the city and provide grant funding for some of these projects. I mean, the purposes seem to address the public realm, quality of life, safety, so that may be one option. Or if you'd like, you could continue it and ask BIRA to appear at a subsequent meeting. It's up to you.
Let me ask Commissioner Dominguez. This is your item. Let me allow you to chime in on your thoughts on this.
Well, BIRA is here, so I'd like to give them the opportunity to defend themselves.
Mr. Chairman, can I speak after BIRA?
Let's hear from BIRA.
Good morning, still good morning, Commissioners. And
What's your name?
Your name for the record, please.
Jack Robbins, Vice President of BIRA.
Thank you.
So, as was mentioned earlier, we started these discussions well over a year ago. Commissioner Dominguez brought the parties together, let us know that the standard was interested in a redevelopment plan, and encouraged us to work with them, and we did so. Over the course of a year, we've had many, many, I think, collaborative, productive meetings, and you see the results of that now that you have the copy of the agreement, Commissioner. You see the results of that yourself. So for the benefit of Belle Isle and Belle Isle residents and Belle Isle visitors, I think this is a big, big win for all parties. Now, you mentioned that you had spoken to the owner, and I would say that what you conveyed based on your conversation is very, very different than the discussions that we've had. By the way, all represented by legal counsel, both BIRA and the developer, and the owner of the standard participating in those as well. So I can't say the nature of the conversation that you had with him and what he may have communicated to you, but that's certainly different than the perspective that we have today. Now, with respect to the community benefit itself, it was important to BIRA that we set it up a separate nonprofit entity because we, for precisely this reason, we did not want there to be an appearance that BIRA was taking some amount of funds and spending it on whatever we choose to do without governance, without any plan. So we chose, again, with legal guidance, to establish this nonprofit entity. It is new. The reason that there are 3 names attached to that, as you probably find in SunBiz, is that's how you set up an entity. You have to have officers. So the officers were named. It was set up by our attorney. There is a plan to begin our governance process where we will name not just the 3 people who are registered as SunBiz officers today, but other members of Belle Isle Residents Association, and potentially people outside of BIRA. We have been talking about perhaps having some member of city staff or even the commission, if they would be willing to do so and like to do so, to be part of that governance process, so that the expenditure of funds over a period of time is open, is transparent, and is part of the community discussion.
Thank you, Mr. Robbins, for allowing for the government to have a role in that discussion. I think that could help ensure that public benefits like this one and others in the future are truly done in the best interest of the public. I'd like to open up the floor to members of the public who would like to speak.
If I could, Commissioner, just one more comment
Yes.
about transparency, because as I said, we've had meetings over the course of a year moving in this direction, but there have been notices from the city to Belle Isle residents regarding this redevelopment. There have been notices from BIRA, and in fact, there was an open meeting that all community members were invited to. The standard themselves conducted a community meeting that they sent multiple mailings to. BIRA sent multiple notices to our email distribution. So I just want to make clear that none of this has happened in a vacuum, and there's never been any attempt to hide what we were trying to accomplish. The community benefit was discussed in many of these meetings. So I just want to make that point clear as well.
Thank you so much, Mr. Robbins. And from my perspective, and I understand Commissioner Suárez, the perspective of the residents who are sitting in front of us today, who live on the north side of the island. I've always seen BIRA representing the residents of the south side of the island, and has always been very clear about that. So it's no surprise to me that residents from the north side of the island wouldn't have been included in these discussions. That's not surprising to me.
And just one more clarification.
Yes,
Commissioner,
and then we're going to move on,
Yeah,
sir.
One more
Thank you.
clarification. We do have BIRA board members, past and present, who are residents of the north side of the island.
Oh, okay.
Single-family homes.
Well, I stand corrected
Yeah.
then. Thank you so much, Mr. Robbins. Okay, I'm going to open up the floor to members, any other members of the public wishing to speak on this item. If there are members attending via Zoom wishing to speak on this item, please press the raise hand icon. Welcome, please state your name for the record. You'll have 2 minutes to speak.
Yes, hi guys, I'm Joe Ferrone. I would like a little more than 2 minutes to speak if I could, because I have a fair amount to say. I have absolutely no objection to the standard plans at this point. I was taken aback when I learned of them so late in the game, and as the previous guy said, they've been negotiating frequently in frequent meetings for over a year with the standard to discuss conditions for the development that's proposed. I live right next door to the development that's proposed. My neighbors live right next door. I've been on Ferry Lane for 15 years. I have never been drafted by BIRA. I didn't even know what BIRA stood for. I knew there was a neighborhood association. I didn't know that was their name. I have never met this gentleman who seems perfectly nice. I have nothing against my neighbors, to the south. But BIRA does not represent me. It never has. I've never received a single notice or email or invitation or anything from BIRA. And so here they are for a year representing, as I understand it, to Miguel and to Michael and to whoever is involved on the standard side, that they speak for us. If I were going to have a party at my house and there was going to be extra cars and maybe a little extra party noise and what have you, I would tell my neighbors. I wouldn't go across to South, Island Avenue and tell everybody who lived in the condos there. It has nothing to do with them. Nothing. So here they are, meeting for a year. Unbeknownst to us, we were told at absolutely the 11th hour about this whole thing and invited to a nice party, but the deal was already done. They managed to get, 1.2, almost $1.3 million to spend at their own discretion. I can guarantee you that not a dime of that will ever accrue to the benefit of the people on our side of the island. And it is weird, and I think, to me, it sounds like extortion. I think that, I was angry with Miguel because normally in this process, what's happened in past years when there was a development proposed for the standard, they were all over the residents of Ferry Lane and Century Lane to some degree, but it really affects us the most. And basically, we would work out a little deal. I mean, there's nothing wrong with, with being a good neighbor and saying, okay, we'll make sure that the trucks don't come down, after 5 o'clock, or they're not going to come barreling down your street, or if there's any structural damage done to the immediately juxtaposed buildings, we'll take care of it, we'll take the responsibility. This whole deal, and because BIRA represented that they were speaking for us, that never happened. It's the first time that never happened.
Thank you.
I was really pissed off about it until I found out that the people I'm really pissed off with are those people at BIRA whose names I do not know because I've never met them.
Thank you, ma'am. I'm sorry.
Have
I have to
said
move
that they
on.
represent my concerns. They patently do not.
Thank you.
And I think they should be called BIRA South
Thank
Island
you.
residents.
I appreciate
Yes.
your comments. Thank you for attending. Any other members of the public wishing to speak on this item? Seeing none in person, seeing none on Zoom. I'm going to bring the discussion back to the dais. So we have this item before us. I do believe this is a good item. I do believe that this is an item that helps the Standard Hotel. I don't think that the residents of the Belle Isle neighborhood did anything wrong in advocating for the needs of their neighborhood and entering into an agreement, just how many other associations may do in other circumstances, entering into conversation with an applicant. I think if I were the applicant, I might be thinking perhaps of reaching out to other neighbors, that perhaps communication may not have been as robust as with the neighbors on the south. But this is a good item. This is something good. This improves an important asset in our city and helps ensure its future. So I think it is proper for this item to move forward today, but making sure that the residents on the north side of the island are not forgotten about. And they clearly, as we're hearing today, don't feel represented by the neighborhood association, and they deserve to be represented as well. Commissioner Bond, you're recognized.
Thank you. I think everybody is supportive of the project moving forward. I think what I'd like some clarification on, Mr. Attorney, is if there are concerns about the drafting of the language of this agreement between private entities, is that something that can be bifurcated and handled separately, or is it not an issue? Because
I'm
I'd
going to
like
stop you there. Hold up. I'm sorry. This is an agreement between two independent parties that we're not a party to, two private parties.
May I restate
Yeah.
my question? I don't think if there is a problem with the way the language is drafted, can we move forward with approving? I'm not clear that there is, because you said on item number 1, there was no implication, but on B and C there might be. So, but it's not the city's issue. The city is here to opine on whether or not the project should move forward. If there is an issue with the language in a legally binding settlement agreement, is that something that the two parties have to take up amongst themselves and address, or what do we do about that? Because I don't know, I'm not a lawyer or a land use attorney or whatever, so I don't want to get involved with that. If it's fine, it's fine. If it's not fine, they need to fix it, but in the meanwhile, the project should go forward. So how do we do that?
The agreement itself, as you stated, Commissioners, is an agreement between two private parties. So, and those parties are in the room. I don't want to speak to what their intent would be with regard to their agreement. Where the city is involved is that our code prohibits contingency fee arrangements of the nature of the second and third payments. Because that's part of the city's code of ethics, it's not enforced by my office or the city clerk's office. It's enforced by the Miami-Dade County Commission on Ethics. So I think if you're asking, does this prevent you from moving the legislation forward while any potential renegotiation or any potential ethics investigation proceeds? I think those could go separately. I mean, I think it doesn't hold the commission back on the legislative matters.
But do the ethics considerations, whether or not there are any, they don't affect us as a government? That would be between the two parties of the settlement, right?
That's right.
We didn't negotiate any part of this.
We did not. No, we did not.
So
yes,
it
that's
doesn't
right.
affect us. So I would move to move this item with a favorable recommendation, and then, the private entities will have to figure out what they want to do about the language.
Mr. Chair,
On the motion to approve the item, Commissioner.
Mr. Chair,
Yes. On the motion.
our Inspector General was the director of the ethics of the county. I mean, I don't know if he can come up and speak to this. And I mean, certainly I don't feel comfortable voting on a matter where my vote is going to potentially make someone a millionaire. Okay, I think that's highly inappropriate. I'd love to see what Joe Santorino says on the matter. And I think the best course of action is to really defer this for now, for 1 month, to the Ethics Commission and see what their opinion is on the matter. Because, I mean, the code is pretty, the code is pretty plain language that any person or entity receiving or giving money based on a contingency of a government approval is strictly prohibited.
So I believe that that is a private matter between two private entities, and that is not anything that the government is involved in. And I am not making my decision based on something that I'm just finding out today, and I don't think any of us should be making our decision based on a settlement agreement between two private parties. That's not how we do land use in our city. We should be doing land use policy as it relates to how is something going to affect traffic flow, how is something going to affect the character of a historic building, is it contextual to an area, and that is the policy that we have before us today. We don't have a policy and a recommendation based on a settlement agreement that I'm just finding out about today. And so, as it relates to a policy-making matter, I think it would, in fact, be wrong for us to defer this as a result of a matter that should not be influencing our vote in any way, whether in favor or against. And I think it should be up to the residents who feel that anything was done wrong to file an ethics complaint about this. This is a matter between two private entities that our city is not a party to, and I think we harm our process when we allow outside agreements like this to play a role, whether for or against a particular party, a particular policy that is coming before us. And Mr. Attorney, please correct me if I'm wrong in any of this.
It's the board's prerogative whether you want to proceed with the legislation. It's entirely your prerogative.
Okay. I think I personally believe these agreements should not be influencing us one way or another. If it were an agreement that were between the party and the city, at that point, I do believe that well, then yes, that is a matter of public policy making. But in a situation like this, I don't believe that we should be holding up policy that's important as a result of a private agreement between two entities, because in the future, people could enter into agreements just to derail policy making. It's not how policy making should work in this instance.
Let me respond to that, Commissioner. I just want to be very careful about the precedent we are setting here today. Okay? I think the community benefit of noise, quality of life issues is great. But just think about for a second what we are doing here. We're going to be voting on a matter that's contingent upon our approval to literally make someone or three people millionaires. I find that so
Commissioner, I'm gonna ask you please stop, because it's not making three people millionaires. It is an independent entity that is supposed to be representing the neighbors of Belle Isle. I think that unfortunately that's a misrepresentation you're putting there. I don't believe this is making three people millionaire. And I see the Inspector General is here. He's been referenced. Mr. Santorino, if you want to come forward and guide us, because I have asked you to work on a red flag ordinance specifically for issues like this one. And so I would actually appreciate you coming to the podium, and please stop us if anything wrong. If we're about to do anything that's wrong, I will completely entertain a motion to defer this item if you feel that that is necessary. Because the one thing I will not allow us to do is walk on the line of ethics. That is a line we do not cross. We are here to make public policy on land use matters. Whether a private agreement was made or not, I do not believe that a private agreement between two private parties should in any way, positively or against, influence policy making on land use, where that is usually not a matter of criteria that we consider. So, Mr. Santorino, you're welcome to address this body.
All right, well, thank you, Mr. Chairman and Commissioners. I'm not in a position to give you an opinion here, because we haven't looked into this matter. We haven't investigated this matter, and I've just become aware of it. I am familiar with, obviously, with the ethics ordinances, but I have no I have no authority to give you an ethics opinion. That is reserved to the Ethics Commission. I am familiar with this provision. I'm not aware that it's been applied in this situation. However, the language, as you know, the city attorney has indicated, is a very broad language. So I can't tell you that the existing Ethics Commission might not find it to be in violation of the ethics provisions. That's something that would have to come from them via a request for an opinion. Then that request could come from the city, it could come from the parties involved, from anybody connected to it. I agree that it's between two private parties. The city is not, committing a violation in this situation because it's not a party, it's not approving any agreement. I would be concerned about it, that insofar as the city attorney feels and has given that indication that the broad language in that ordinance could be interpreted to apply to this situation. And the only way to clarify that or get that issue resolved would be to get it to the Ethics Commission and get an opinion from them. And, everybody then would know which way things are going. I would think that if there is a problem with it, probably, since I don't think the contingency, any of these contingency type payments have been made, there's a chance to amend the provision, maybe to avoid that.
Mr. Centurino, let me ask you, the outcome of any review by the Commission on Ethics on the private agreement, what influence should that have over our decision on the policy? Should it weigh one way or another on this zoning policy?
Well, I'm the advocate not just of following the law. I'm an advocate of public trust and avoiding doing anything that might diminish the public trust. So if there is a sense here that, it would be better to have the Ethics Committee weigh in before you take action, the only consideration there is not the legality of it, it's the perception of whether somehow, by virtue of the city taking action, you're, in effect, going forward with at least something that somebody's raised a question about. I'm not saying that there's any violation here, but I would rely on them to do it. So I think that's a judgment I think ultimately, as public servants, we have to make every time we do anything. Is there a public trust issue here or not? And, that's something that, you obviously should think about, but that's not something that I can, at this point, give any direction to.
And Mr. Attorney, can this commission request an opinion from the Commission on Ethics before we move forward? Is that something that the committee can do?
Yes, we can do that. Yeah.
Okay. Well, given the comments placed on the record by Mr. Centurino, then I believe that would be the most appropriate thing to do, because as you mentioned, it's not necessarily the legality. It doesn't mean that this item can't move forward, but it's the matter of public trust and public perception that matters just as much. And if an action that the city is not a party to, is creating that situation, then it's something that we need to consider. But I just will put on the table. I'm glad that we're having this discussion, because I think the three of us sat in a committee meeting probably 3 or 4 months ago where I brought an item relating to transparency of neighborhood associations. Formalizing neighborhood associations, having public meetings for neighborhood associations, having advertised meetings and advertised elections with set geographic boundaries. Everything that was mentioned today that was not done with this. And the item was turned down. It is precisely because of situations like this why I proposed that. Because neighborhood associations do represent residents. They do engage with applicants. They do play an important role in the process. And residents today are complaining that perhaps something should have been more transparent, that perhaps they should have been more represented, that perhaps a geographic boundary should be better defined so that people can know who's being represented by whom and who is not. And so, it's just something for us to keep in mind in the future. Number one, neighborhood associations don't act on behalf of city commissions. But number two, perhaps we need to enhance on the transparency that we have in place, and formalize some of these neighborhood associations so that we don't find ourselves in this type of situation again in the future. Commissioner Suarez, thank you for advocating for the public. What I don't want this to look like is that the residents did anything wrong or illegal, because they did not. The residents of Belle Isle were advocating for their neighborhood in a private agreement between two parties, just how many other organizations may have done in the past. And Commissioner Dominguez's item, I think is a very good item, and it shouldn't be publicly tainted in any way in the public's perception of it, because of a private agreement between parties that the city is not involved in. But I do believe, because of the comments placed on the record by the Inspector General, that it might be in good public optic for the public trust to allow the Commission on Ethics to weigh in on this before we move forward, so that we make sure that there's no questioning on the process. So
I think we have to withdraw the motion.
So, Commissioner Dominguez, you're, okay. So,
I'll
do you want to
withdraw.
amend your motion?
I'll amend it to refer this to the Ethics Commission and hopefully get a response so that we can hear it and vote on it next month.
And do we think that that might be possible, Mr. Attorney?
I will reach out to them today, and find out what their timelines are generally.
Okay. So, and we need to work on two things. Number one, disclosure. We need to educate the neighborhood associations that may not know of this provision, because again, neighborhood associations don't follow our codes. They have no reason why to know they exist. They innocently are getting in the mix of something very ugly, not knowing of a regulation that might apply to them. So I think we owe it to them as a courtesy for the volunteer work that they do for us to let them know of this provision. And number three, I think we just need to work on, again, that legislation on neighborhood associations to make sure that we maintain a level of organized transparency in that local level of community work.
Let me end off with this. Like I said, I think this project is great. I certainly don't blame the business owner. I don't have any fault to the sponsor of this item, but the fact that, you know, we have a land use attorney who's been working since '98 in Miami Beach, who should have known these laws, and who should have known exactly the laws where there's a prohibition on contingency fees, is what I find unacceptable. And so, you know, I think, you know,
Thank you, Commissioner.
the issue should be really investigated at the representation level.
Thank you. All right, there's been a motion and a second. Can we show that by acclamation?
Yes.
Yeah.
Thank you. And colleagues, I know we're all doing this in the best interest of the public, and I do firmly believe in that. I just, you know, any comments, we just have to be careful not to seem attacking individuals. I mean, that's my only hesitation with the tone of this discussion, is that it felt like, you know, three individuals were being attacked when they were just volunteers looking out for the best interests of their community. The same way that at times we might get attacked, you know, when we're just volunteering for the best interest of our community. So with that, let's move on to item